Good afternoon. Welcome on into From Day One. We'll get started right away. With somebody you have to question why they're doing that way.
Alright, and so we are going to go on the record in the matter of people of the state of Michigan versus Tobias. And I also believe that Mr. Keith did send you a copy of the motion, correct? Alright, and so are the people prepared to proceed on the motion?
Yes, Your Honor.
Okay, Mr. Taylor, are you ready? Are you prepared to proceed on the motion? Alright, and the court will note, based upon the emergency motion filing and your late appointment, the court will still allow you to permit you to make oral argument without submitting a response, a written response, okay? All right, and so Mr. Kasich, you may proceed.
Yes, Your Honor. The people are requesting that it's fine. Cash bond. As we tapped the defendant's statement, the defendant was given a $5,000 personal fine. That the court that he raised as not properly considered. These are exactly what the court should consider when saying personal fine, and criminal history, likelihood of ignorance, and safety of the community. In this case, Your Honor, we have an individual who is just released from alcohol for another normal case with status of fourth degree ritual offender, and right after being released, he was still in the car, driving 90 miles an hour in the city of Detroit, not only endangering the lives of the public, but also severe risk officers involved. We believe that there needs to be some cash bond, not only ensure the defendant appears, to ensure that the type of behavior shows that in this case will not be perpetrated while he's on bond on the current case. I certainly think a $5,000 personal bond where the defendant there's nothing to force the defendant to appear in person for the court date. It's substantially just not appropriate in this case that a substantial cash bond needs to be I would without discretion for Your Honor, I don't think this bond is appropriate. Given all the factors to support the court will consider this bond.
So if
All right, thank you very much. And Mr. Taylor.
if you're not realizing, they're arguing that the guy just got out, just went high speed against cops and everything else. So they're arguing that personal recovery bond that the judge said previously is definitely not what should happen. Let's hear the defense.
Yeah, I'm not trying to make excuses for my client, but actually what he did, he don't harm himself more than anybody else. He has a splinter spleen and I think his pelvis is broken too, and he has a tether already, and he really can't even get around good. He's going to therapy, so I think if he's remanded, he's not going to get proper help. So I think the minimum bond would be proper. He has a tether already.
Is the tether as a result of his MDOC parole, or is it as a result of his bond?
It is MDOC parole.
Okay.
He's under house arrest.
He's on house arrest.
Just indicated that.
And so are there specific terms regarding your house arrest? Are you permitted to leave the home for work?
I could leave the home for work, but at this time I can't walk. My hip is fractured in my pelvis. I can't walk. I got physical therapy appointments coming up.
Okay, hold on, sir. My question was, are you permitted to leave your home for work?
Only for work.
Okay, so that yes?
Yes, ma'am.
Okay, so where do you work?
Pack right.
And so what are your hours?
I had just started. I was working midnight shift, 10 to 6.
That's 10 p.m. to 6 a.m.
Yes, ma'am.
What days of the week, sir?
I had just started, so that was my first day that I got to this thing. I don't know.
So your first day was October 21st?
Yes, ma'am. So as of right now, I can't go back and work because I can't lift more than 60 pounds, so I can't walk.
Okay, and so where's Packright located? And yet this incident alleges that you were in the area of 7th and Cherry in the city of Wyandotte at the same time you should have been working.
Uh-oh.
And so you were not at work that day, even though your tether allows you to be out for work purposes, you do not appear to have been at work that day.
I was never on the tether until after this incident that we're here for right now. For this incident, they put me on the MDOC tether, house arrest, and I got to go to treatment, physical treatment for physical therapy, and also like counseling.
Okay, so you were on parole.
Yes, ma'am.
Your parole in September.
Yes, ma'am.
And you were not have a GPS tether at that time.
At that time, because of this incident, that's why they put me on the tether.
So when were you placed on the tether, sir?
The Monday after the incident, we all let you out.
So when y'all let you out, who let you out? This court did not do that.
No, the magistrate, Your Honor.
What city are you living in?
Lincoln Park, Michigan.
Is it the address on file or are you staying somewhere else?
Staying on file because I have to be there on my house arrest, so that's how I violated the system. Automatically being monitored at 24/7. I can't even leave because I can't walk.
Well, you can walk with the assistance of a walker, right? Yes?
And proper medication, which is not going to give me anything like a facility.
And how do you know that, sir?
Because when they tried to take me there last time, they said they wouldn't give it to me.
Who's they? When they tried to take me there last time, they wouldn't give it to you.
Might not try to take me to MBOC to hold me. And that's why they put me on the tethers. I can't walk. I can't have my walker. I got to do my physical therapy appointments. I'm rocking the heel right. I got 3 months of physical therapy. I got to get my stitches taken out, which are currently affected right now. I can show you. I just left the hospital yesterday for that. I got papers to prove a prescription for the patient. I understand I made a mistake. I also was doing good too. But there's no excuse. I did, I was grateful I didn't hurt nobody. I just asked, at least let me be able to do my doctor's appointments. I came here today, I'm not no flavorist. I'm here to do my house arrest. I'm not telling my going nowhere. So I just pray for me to keep the body safe. You see, I'm not running. I'm trying to change my life this time.
And sir, what is the curfew that you have to abide by? Prior to your tether, what is the curfew?
Oh, I come out from like 8 in the morning to 11 at night.
So 8 a.m. to 11 p.m. was your curfew prior to this incident.
Yes, ma'am.
This incident is alleged to have occurred at about after 3 o'clock in the morning, correct?
Yes, ma'am.
So outside of your curfew time, correct?
Yes, ma'am.
Right. Anything else, Mr. Kizak?
No, Your Honor. Again, I think the court's fully apprised of that situation together. Just more motion for
Right. Anything else, Mr. Taylor?
this court take law the matters for consideration.
Right, thank you. And pursuant to MCR 6.106H2A, and prior to the arraignment on the information, this court may modify a prior release decision on motion of a party or its own initiative on finding there's substantial reason for doing so. After hearing from Mr. Kazak and hearing from Mr. Taylor and Mr. Catron, the court will indicate the following. In this instant case, the defendant, Tobias Catron, has been charged with fleeing, eluding third degree. This charge is a felony charge with an enhanced penalty of up to life imprisonment if convicted, and that's due to the habitual offender fourth offense notice. Mr. Tobias was arraigned by a judicial officer of the 36th District Court, not by a judicial officer of the 27th District Court. The bond that was set on October 23rd was a $5,000 personal bond. There was not a GPS tether provision, just the standard provisions of appearing in court and not consuming alcohol or any other drugs are not prescribed, and not leaving the state. This court does not know what factors were taken into consideration at the time the bond was set by the 36th District Court judicial officer. The court will note, however, that in determining pretrial release of the defendant bond and conditions, judicial officers do have an extremely difficult task of balancing the safety of the public with the accused's constitutional right to pretrial release. Sometimes the judicial officers may not have all the information, as the complete criminal history of the defendant is sometimes not known. In reviewing the criminal history of this defendant, what has been made abundantly clear to this court is that the defendant's current CCH was not completely accurate. For reasons not clear to this court, there are charges as well as convictions that are not appearing on the CCH but do appear on the Third Circuit Court Register of Actions and the 25th District Court's Register of Actions. The court will also note that back to 2015, when the defendant would have been around 19 years old, the defendant has had 25 criminal charges, of which 22 are felony charges. Of those felony charges, the following have been convictions. 2016, 3 counts of assault with dangerous weapon, also known as felonious assault. 2017, assaulting, resisting, obstructing an officer. Another charge and conviction of 2017 of assaulting, resisting, obstructing a police officer. In 2018, another charge, conviction of assaulting, resisting, obstructing a police officer, and possession of a firearm by a felon. I believe these are the convictions that the defendant is on parole for. And then in 2019, additional 3 counts of assaulting, resisting, obstructing a police officer. Some of the other criminal charges the defendant has faced include assault with intent to commit murder, assault with intent to do great bodily harm less than murder, domestic violence, assaulting, resisting, obstructing an officer causing injury, including additional weapons offenses, and another charge of fleeing and eluding, which is the same charge the defendant is before this court on. The court will also note the defendant was paroled a mere 23 days prior to this incident. One of Mr. Catron's conditions of parole was not to engage in any behavior that constitutes a violation of any criminal law of any of government. Another condition was Mr. Catron was to abide by the specified curfew as directed, as Mr. Catron indicated, was 8 a.m. to 11 p.m. The court will also note that this offense is alleged to have occurred sometime after 3 a.m., which is well after Mr. Catron's curfew. Pursuant to MCR 2.106A and MCL 765.6, a person accused in a criminal offense is entitled to bail except in certain circumstances. Bail should not be excessive, and the court must take certain factors into consideration. Further, pursuant to MCR 6.106B1 and the Michigan Constitution, Article 1, Section 15, it does allow a court to deny pretrial release to a defendant charged with committing a violent felony when, at the time of the violent felony, the defendant was on probation, parole, or released pending trial for another violent felony. Within this several, violent felony is a felony, an element of which involves a violent act or threat of a violent act against another person. Based upon what the court has heard, pursuant to MCR 6.106H2A, this court does find that there is substantial reason to modify the prior release decision of Mr. Catron. In determining Mr. Catron's bond and conditions, the court has to take into consideration the following: defendant's prior criminal record, including juvenile offenses, defendant's record of appearance or non-appearance at court proceedings, or flight to avoid prosecution, defendant's history of substance abuse or addiction, defendant's mental condition, including character and reputation for dangerousness, the seriousness of the offense charged, the presence or absence of threats, and the probability of conviction and likely sentence. Defendant's employment status and history and financial history, insofar as these factors relate to the ability to post money bail. The availability of responsible members of the community, including family ties and relationships and length of residence. And finally, any other facts bearing on the risk of non-appearance or danger to the public. Taking into consideration the first factor regarding defendant's prior criminal record, the court will note the defendant has an extremely lengthy criminal history, which is littered with assaultive crimes, weapons offenses, 14 charges of resisting and obstructing a police officer, as well as a prior charge of fleeing and eluding. As to defendant's record of appearance or non-appearance, there is not a significant record of defendant's failure to appear. However, while defendant has been on probation for previous cases, he has had warrants out for his arrest for probation violations. As to the factor of defendant's history of substance use or addiction, this factor is not considered as there does not appear to be a history of substance use or addiction that has been placed on the record or in the pleadings. As to defendant's mental condition, including character and reputation for dangerousness, the court will refer to defendant's criminal history and its prior statements regarding the dangerousness of Mr. Catron. As to the factor regarding the seriousness of the offense charged, this is a very serious charge. With the primary offense of fleeing and eluding third degree being punishable by up to 5 years imprisonment, and defendant's habitual offender fourth offense notice, the potential sentence for the defendant is up to life imprisonment upon conviction. Probability of conviction based upon the body cameras and potential evidence in this case is high. Further, as the defendant was recently paroled prior to this incident, the likelihood of the defendant being sent back to prison is extremely likely. As to the factors regarding defendant's employment status and financial history, the court will note that the defendant indicates he just started the job the day of this offense, and so that factor is not taken into consideration. The availability of responsible members of the community, the court does not have much information on that. The court does not have much to take into consideration on that factor. Any other facts bearing on the risk of non-appearance or danger to the public. While the court will note that Mr. Catron is here today, the court will also note that the risk of the danger to the public is extremely high. The defendant is alleged to have reached speeds of up to 90 miles per hour in and out of neighborhoods. There is a common statement that this is a non-assaultive crime. And Mr. Catron, while the court will note that you are the one that was injured, by the grace of God, this is still a non-assaultive crime, as innocent bystanders were not injured or killed due to your egregious actions. Your recent parole status is a colossal factor this court must consider when determining your pretrial release and conditions. Additionally, the charges that are alleged in this case are that the defendant reached speeds of up to 90 miles an hour, trying to lose the police while fleeing through residential neighborhoods and went through multiple communities over an approximate distance of 16 miles an hour at an extremely high rate of speed before ultimately crashing. All of this is alleged to have occurred while the defendant was in a vehicle that had been reportedly stolen. This all alleged to have occurred during the time when the defendant was supposed to have been home during his curfew as ordered by his parole. This behavior shows a complete and utter disregard for the safety of the public. This behavior shows an utter and complete disregard for the orders of a parole agent as well as additional court orders. The defendant has been unable to comply with the terms of this parole release. The defendant failed to show this court that he's able to abide by this court's conditions. Based upon all of the foregoing factors, hearing arguments by counsel, the legal authority by which this court may act, the court is modifying the current bond. The court finds a $5,000 personal bond in this matter is woefully inadequate. The court is going to issue a bond in the amount of $250,000 cash or 10%, no surety. In the event bond is posted, you shall not be released on GPS tether, house arrest. Please don't interrupt the record, sir. You're not possessing or consuming alcohol or drugs that are not prescribed. You're in compliance with all parole supervision orders. And quite frankly, the court's going to indicate a $500,000 cash bond, no 10%, no surety based on the defendant's behavior here in court. The court will mark your file medical, so you may receive the medical treatment that you need. Anything else? Anything else for the people?
No, thank you very much, Your Honor.
Anything else for the defense?
No, Your Honor.
All right. Now, that's as it relates to the motion hearing. As the probable cause conference is scheduled for today, also it's my understanding this matter that the defendant has waived his preliminary right to preliminary hearing. Okay, hold on. We do need the defendant here.
Mike touching on me, right? Touching me.
Mr. Catron, please.
So I step over here.
they're gonna give me a personal money again.
Please return to the table so we can complete the probable cause. All right. Mr. Cantron, you heard what your attorney indicated, correct?
I waive my preliminary. Let's go.
Sir, I understand you want to get this
But you
moving,
said all the
but I need.
you said I would be here, medical, nothing.
Stop.
Stop working with them. Just send me down time.
Sir, I need to make sure we have some stuff on the record. So please stop. Stop. That's fantastic.
I'm here. I waited preliminary.
All right. So I just want to make sure that you do understand you have the right to have an attorney. You had one appointed to you today, correct?
I gotta understand all.
Do you understand that, sir?
I waited. I sent it to myself so I get time to come home.
So you have the right also to preliminary examination or must be shown a crime is committed and probable cause exists to charge you with that crime. You understand that? All right. Does anybody promise you anything, threaten you, or coerce you in any way for you to waive your right to your preliminary examination today? You also understand that by waiving your right to your preliminary examination, you understand that you'll be bound over to circuit court on the charges in the complaint and warrant. All right. The court will indicate that examination has been waived. Defense bound over to circuit court. You are to appear in circuit court on November 10th at 9 a.m. Anything else for the people?
No, thank you very much, Your Honor.
Anything else, Mr. Taylor? All right.
Mr. Taylor's like, can I get the fuck out of here, Your Honor? This guy's going crazy. All right, with that, we will bring in session 2 a close. Please make sure you do like, share, and subscribe. Help us get to the 50,000 views, 1,000 subscribers. So Boxy sends us nice red buttons and Google puts us on the algorithms. Come back tonight for more as we continue to march along here from day one. Have a great afternoon, everybody.